Hey guys, let's talk about Fani Willis. Nobody's talked about that case yet, have they? Yeah, I think they have. But what we're going to try to focus on in this video is just this is something elemental to this. What are the standards that the judge should use to decide whether she gets thrown off the case or not? It's a little bit murky. It's also lost in a lot of the sleaze and accusations and arguments and stuff like that. So I want to bring it back to that because that's what the judge should do. And that's what the judge will do, whether you ultimately agree with his decision or not. He's going to at least frame it in terms of the legal standards. And I'm sure that he's going to try to apply them correctly. So you probably know that the defendants want some more evidence brought into this case. The judge was, in theory, going to be making a decision. So who even knows whether he's going to reopen it yet? I haven't heard to hear any more evidence, but I think we got the picture, right? So anyway, let's take a look at this. The judge is going to have, as you'll see, some room to interpret. There's a lot of discretion. If this goes up to appeal, it's only appealed on abuse of discretion. It's murky, but there are legal standards, and you're going to know them when we finish with this. There are two, basically, according to Georgia case law, grounds to disqualify a district attorney. The first is called forensic misconduct. That sounds terrible, doesn't it? And the second is called a conflict. So those are your two right there. You can stop watching if that's enough for you, but I'm going to try to explain it. Something a DA does, okay, may be one or the other or both. Some action could fall into just either category, or it can be evidence of both. But which category it falls into is really important because they are applied legally significantly different impact and how it goes. And that's what we'll talk about. So let's look at the first one, forensic misconduct. So that could be statements. A primary example of forensic misconduct is an improper expression by the prosecuting attorney of personal belief in the defendant's guilt. And if you're a layperson, that may be kind of surprising. The prosecutor should believe that they're guilty, right? But they're not supposed to express their personal opinion of that. They are supposed to rely on the evidence in the courtroom and not express their own opinion inside the courtroom or out of the courtroom in an improper way, especially outside the courtroom, okay? So now for this kind of thing, the court can look at, the nature and extent of the comments. Was this one off the cuff remark that didn't really impact things? Or was this part of like a plan? The prosecuting attorney is engaging in serious behavior to try and undermine the defendant's right to a fair trial. That matters, right? And that's also important because of the second element that you need if you want somebody disqualified for forensic misconduct, and that is to show harm. So one tiny comment in the course of a trial that's 10 weeks long, that may not be harmful, but an all-out press assault before a trial or repeated statements during a trial that are improper, well, that can be harmful, right? And in that case, it could result in a verdict being thrown out or the DA being taken off the case and the thing done again. So you got to show those two things for forensic misconduct. For example, in Lamb v. State, the higher court rejected the defendant's argument that the indictment should be dismissed based on the prosecuting attorney's statements to the press. The court said, look, you haven't shown how those statements actually harmed you in the trial. So you could see how that could be relevant to what we're talking about here, right? Because of the church speech and other things like that. So the idea that you need to show if you're going to talk about prosecutorial misconduct or forensic misconduct, some harm, that's pretty important. Now, the second ground for disqualification is a conflict. And that's an easy one. Now, the second ground for disqualification is a conflict. Here's an easy one. The district attorney previously gave advice to the defendant about this charge, and they maybe got appointed onto the case. You can't do that. Maybe the district attorney is the sister of the victim. That sounds like a conflict, right? But Georgia law also says there's a conflict when the district attorney has a personal stake in the outcome of the case. Now, what does that mean? So an easy example of that, it's not going to be something that happens, but it has happened, I think, is if the prosecuting attorney were hired on a contingency fee. So if you get a conviction, you get this much money, but if you don't, you don't. No. That's a personal stake in the outcome of the trial. And outcome is an important word for this case because we're not to the outcome yet. And for the alleged conflict, is it for the case itself or the outcome? You'll see what I mean. But anyway, you get the idea, right? So if you've got an identified reason that you have a personal investment in the outcome of this case beyond the facts of the case, that could be a personal conflict, okay? Now, for example, another judge has already found that Fani Willis had a conflict in another political case where she was prosecuting the political opponent of someone whose campaign she was openly supporting. And so the judge there said, listen, every move you make in court or even before that against this person will be to the benefit of somebody that you're actively supporting their campaign. That's a conflict. That's a real conflict. I can't let you stay on the case. So now the big difference between a conflict as a ground and forensic misconduct is you do not have to show actual harm if there's a conflict. The finding of a conflict, though, it can't be based on speculation or just theoretical or the hypothetical appearance of impropriety. You have to show a conflict. But once you do show that conflict, you don't have to show any harm from it. That's assumed. There is an assumed, when there is a conflict, appearance of impropriety in how the prosecution is being conducted, and that's enough. That's in Georgia court and the United States Supreme Court. So if there's an actual conflict, then the prosecuting attorney needs to get off of the case. So obviously, if you're a defendant, you'd like for the judge to find a conflict because you're done if you win, if you do that, versus forensic misconduct where you've got to show the misconduct and you got to show how it harmed you. So conversely, if you're Willis and you want to stay on the case, you do not want the judge to find a conflict because you're done, you're cooked, right? You don't want forensic misconduct either, but at least you can then argue, well, even if I shouldn't have said that, they haven't shown that it harmed them in this case. We can voir dire jurors, make sure that we're picking people that didn't hear anything that I said. In fact, I think her attorneys even made that argument. So you got a couple of chances on forensic misconduct to try and dodge being thrown off the case versus just one on the conflict side. So the primary conflict alleged here, at least as I understand it, and there's a lot of facts and nuance in this case, is the financial benefit, this personal stake in the case, the defendants say. I almost said outcome there, because is it really about the outcome of the case? There's no indication that from the money that her boyfriend's getting that she's going to get more money on the outcome, but there is hypothetically, right, that she's going to make money if she wins this case. That may be a little speculative unless she's got a book deal. Does she? I mean, I don't know all the facts of this yet, but I'm going to stick mostly with talking about what's going on with the boyfriend. So the defendants have said the prosecution of this case has become a way for Willis to financially benefit. She gets a salary, right? But by prosecuting this case, she can appoint people, and she's appointed this boyfriend, and then he takes her on vacations and spends a lot of money on her. So by having this case drag on and be litigated a lot, she's seeing money flow to her. Now, she denies this with the argument that she paid it all back in cash. I don't know. I don't know about that one. But she's also saying, I think her attorneys are arguing at least, that, well, even if she didn't pay it all back, that's not a stake in the outcome of the case. Okay, that's her boyfriend buying her things, and maybe she's violated all these rules and stuff, but it's not a conflict in the case against the defendants because it doesn't depend on the outcome of the case. But it does depend on the existence of the case, right? Now, I think this is going to come down to, at least unless you buy the "I gave it all back in cash" argument, it's going to come down to whether the judge thinks stake in the outcome is so limited that it does not encompass the prosecution along the way. But there's a lot of case law about that in terms of a conflict of an interested district attorney can put a citizen through a lot of trauma on a case that shouldn't occur in the first place. So if that's the nature of the conflict, I don't know that it should be staked only to the final outcome of the case, right? So and the judge has some thinking to do on that, I think. The argument is, of course, she's getting money beyond her salary, like we said, by having her boyfriend on the case. But if she weren't going on these cruises, does anybody think, well, she just wouldn't have done this case? If I couldn't take a cruise or go to Tahiti or something like that, I wouldn't have prosecuted this case. Of course not. I mean, she's motivated to prosecute this case against Trump and the people aligned with him. I think that's obvious. Obviously, his supporters do, because they just want her off the case, which is understandable because they don't want him being prosecuted for this, and they think that she's crooked. And maybe she is crooked. It's going to matter whether she's crooked in the sense of having a conflict or forensic misconduct. Now, there are a lot of other things that can be thought about her or about the defendants or anything else, but for this issue, this should be the defining standards, right? So there's the statements she's made too, right? Has she made extrajudicial statements of such a degree that she's indicated her personal belief in the guilt of the defendants, or other statements about the defendants that is designed to impact whether they get a fair trial or not? And if she has done that, is it gone to the level of misconduct? And then if it has, can they show how that has harmed them? And I wouldn't disregard that second element for reasons of I don't know, because I haven't read all the record whether they've tried to establish that. I didn't really see it in the stuff that I did read. But the judge could always say, well, this has happened, but we're not at a phase that we can tell whether it has truly tainted the jury pool or not. Of course, the judge could say, well, I think it has. It's gone too far. But it could be, almost a, well, we're too early to tell type of thing, because you do have to show the harm. So don't get it, twisted that, well, if she did any kind of misconduct, she should be off the case, because that's really not the law. The law is you have to show an impact from that unless you can show a conflict. Now, of course, the combination of all these things could indicate a conflict. You don't just have to look at one piece of the puzzle. The judge doesn't have to pretend to be blind to the overall picture of what the evidence shows. Like I said, acts can fall into one or the other or both of these categories. So the judge can look at the whole picture, the statements and everything else along with the money, and decide whether there's a conflict or not. Now, the case law is also clear that while a prosecuting attorney, you may know this, has some obligations in cases that other lawyers typically don't have, civil attorneys, defense attorneys and stuff, regarding behavior, but they're not held up to the standard of a judge. So when you think of what would get a judge kicked off a case, it's not exactly the same thing that would get a DA kicked off the case. And the case law says that kind of level of impartiality, that's not the requirement. We're looking for an actual conflict here, not really just the appearance of one. But when there is one, you're gone. So now, can you think about the evidence in this case in light of these two standards without already framing it to the conclusion you think should happen? It's pretty tough, isn't it? You probably got an opinion on it without reading any case law, because you either think, well, she needs to be able to stay on the case. Her personal failings, if they are there, don't impact the fact that there was an indictment and she should be able to pursue it. Or you think the whole thing's a sham anyway, and it's that this Band-Aid being ripped off of what she was doing with the boyfriend and the money and stuff like that just validates that this is all a crock anyway. So I get it. It's hard to renew and think about it fresh like that, but that's what the judge is supposed to do, right? That's the judge's job. He's not supposed to have any thoughts about this one way or the other. And it's supposed to look at the evidence that got laid out and decide whether, for this case, this district attorney has engaged in either one or both of those grounds sufficient enough to cause her, and by extension, her office, to be disqualified. All right, let's recap it, because that was pretty quick, I think. I'm sure I know what all I said. 2 possible grounds. Forensic misconduct, that requires a showing of harm. That can be statements. So you got to show the misconduct, you got to show an effect. Or the second ground, a conflict. And if you can show an actual conflict, not just a hypothetical one, not just one that might arise in the future or could possibly exist, if you show an actual conflict, you don't have to show any further harm. She should be taken off the case. Behavior and acts can fit into one, the other, or both. So we'll see how the judge applies these 2 standards. If he takes Willis off the case would certainly be in trouble, right? So this is a pretty important, maybe critical decision he's going to make. That's it. Thanks. Bye. And let's pop it on out of here.